Good afternoon. Be seated, please. We're here on case number 2440248, MD by Stuckenberg versus Abbott. And you all know the drill. I won't insult your intelligence, so we will recognize Ms. Ho, first of all, please.
Good afternoon, Your Honors, and may it please the court. For over 5 years, the state defendants have made extraordinary efforts to comply with the district court's sweeping, institution-wide injunction and fulfill their responsibilities to the children in their care. They've spent countless man-hours, $150 million on compliance efforts, and $60 million on monitors to restructure the state's already complex foster care system, a task that involves addressing intractable, far-reaching, and incredibly complex societal problems, often in real time. But despite these tremendous strides, the district court has threatened perpetual federal court oversight, even the nuclear option of receivership, and held state executive officials in contempt, imposing immediate, unavoidable daily fines of $100,000. That order, resulting from the district court playing a role essentially indistinguishable from that played ordinarily by state executive officials, raises serious federalism concerns. It should be reversed for one fundamental reason. It metes out a criminal penalty in violation of due process and sovereign immunity. Even if plaintiffs could have proven civil contempt, reversal is still required because the state defendants substantially complied with the district court's extensive institution reform injunction. Of thousands of investigations, the district court took issue with 38, and according to the court's own monitors, 95% of defendants' investigations complied with Remedial Order 3, and 84% complied with Remedial Order 10. That's a significant improvement from 5 years ago, and it forecloses any contempt finding. When it comes to institutional reform injunctions that regulate core areas of state responsibility, fractions of percents aren't near enough to warrant contempt, much less the Damoclean sword of receivership. The district court's conclusion otherwise requires reversal. Make no mistake, the penalty here bears all the hallmarks of a criminal penalty. First, this sanction is punitive, not coercive, because it punishes past conduct that occurred before the order issued. It doesn't coerce future conduct, because there's nothing the state defendants can do now to change how those investigations were conducted in the past. And second, this sanction isn't compensatory. My friends on the other side don't dispute this. Third, the sanction was imposed for asserted violations of a complex injunction. Each time that injunction has come before this court has acknowledged the injunction's sweeping nature. Even standing alone, Orders 3 and 10 are sufficiently complex. Were there any doubt, just consider the over 100 pages it took the district court to evaluate 38 investigations. If anything, the orders here are much more complex than the injunction in Bagwell, which held that the more complex the injunction, the more important the procedural protections. And let me address the certification requirement and the suspension of the penalty. The certification requirement and suspension of the penalty is a smokescreen, Your Honors. What must be certified is that already closed investigations substantially complied with the remedial orders. But the state defendants can't go back in time and change anything about those investigations now. Plus, the order makes clear that the fines aren't in any way purgeable. The suspension merely abates payment pending a compliance hearing, at which point, quote, any previously abated fines may be reinstated. And that's ROA 53129.
But can't the state explain instances of non-compliance? I mean, somewhere in the briefing, I got the flavor that basically what the state needed to do was come in for the past investigations, come in and say, here's why we did what we did, here's why it didn't, specifically comply or to comply to the letter, but it substantially complied. In other words, can't the state really cure those by just explaining lapses? Or, in other words, well, yeah, I'll ask that first and I've got to follow up.
Certainly. No, Your Honor. And in part that's true because the district court held the state defendants in contempt and necessarily rejected the state defendant's substantial compliance defense in imposing contempt.
Did the state go after the instances of noncompliance? Was there a granular finding where the state explained those, or was it substantial compliance more broadly?
We took our cue, Your Honor, from the monitor's own reports. So our substantial compliance defense, to avoid sort of messy factual issues, we relied on the district court's own monitor's report. So I think an important point that's inherent in your question, Judge Wilson, is what's the proper way to view substantial compliance or compliance for purposes of an institution-wide injunction?
Hold that thought, because I do want to ask the follow-up. This is something that's puzzled me. If the state can't cure past instances of noncompliance, these prior investigations, then the contempt fine goes on ad infinitum? In other words, because it's per day, right?
Yes, Your Honor, it is per day, and it's actually worse than that, Your Honor, because even if we had, I guess day one would be as soon as the order issued, which ordered us to pay $100,000 a day into the court's registry.
Until there's a certification.
Until there's a certification, and until there's a and at a future compliance hearing, any previously what the court called abated fines may be reinstated. So I think your question is highlighting that what we have here is not the ability to purge, because any fines can go on ad infinitum, Your Honor.
Am I thinking about this the right way? It's hard to square the circle. If the fines go on daily until there's a certification that you were in compliance, but the state can't go back and cure noncompliance, I don't know how to make sense of that. Like, when does it end? And maybe that's a question for counsel opposite, but
Your Honor, and I think that's actually the clue that tells you that what the fundamental nature of this order is. It is a criminal. It's criminal contempt, right? It intends to punish past conduct, and courts are of course free to impose criminal contempt sanctions, but they can only do so after providing the due process protections under the Constitution, and they cannot impose retrospective criminal penalties without violating sovereign immunity on top of that.
But what do we make of the daily accrual going forward?
Well, Your Honor, I think that's more proof that what we truly have here is a criminal sanction. And let me say this, Your Honor, even if you disagreed with me and found that parts of the order are coercive. We know it's not compensatory. No one's arguing that, right? So the only way it's civil is if it's coercive. Even if you disagreed with me and found there were parts of the order that are coercive, which we dispute, but let's say you disagree with me on that, I think it's indisputable, Your Honor, that this injunction punishes past investigations, that we cannot do anything now to go back in time and change what happened in already closed investigations. And this court and the Supreme Court have made clear that if an order is criminal even in part, the court must afford protections before imposing that which indisputably weren't implied here. And that's this court's decision in Stewart and the Supreme Court's decision in Nye, Your Honors.
You were getting to substantial compliance and what that means. I didn't mean to divert you from that, but I appreciate the exchange.
Certainly, Judge Wilson. And again, yes, Your Honor. I think if it's been 15 years since this suit was first filed. You're right, Your Honor. It's been actually 5 years since the injunction was first entered, an injunction that has been repeatedly before this court, and this court has reined in the district court's overreaches. I think you are looking, the court took issue with 38 investigations out of thousands, Your Honor, where the court's own monitors agreed that 95% were in compliance with Remedial Order 3 and 80-some-odd% were in compliance with Remedial Order 10. So in the context of a sweeping institutional-wide injunction, Your Honor, I think the question is, have we substantially complied? And I think by any metric, Your Honor, those numbers which come from the court's own monitors indicate our substantial compliance. Were it otherwise, Your Honor, even under the view of my friends on the other side, and I assume the district court, even one foot fault, even one investigation that the monitors disagreed with would be grounds for holding the state defendants in contempt. And we know that can't be right, Your Honor. So that just leads back to the importance of the substantial compliance framework. And I think under any understanding of that term, under any metric, we have substantially complied. Yes, Your Honor.
Yes, let's think about what happens. Suppose we were to vacate this criminal contempt. What would happen in the district court? It seems to me she has two options. One of them is to conduct a criminal jury trial with the appropriate burden of proof, and the other one is to possibly drop or modify the sanctions and call it civil contempt. Of course, the third one is to pay attention to the motion to, under 60B5, to terminate the decree, which apparently she's sitting on at the moment, but I don't think that's likely right now. So what am I missing here? Does this really help the state out even if we vacate?
Thank you for that question, Your Honor. I agree with your first possibility that it certainly remains for us to have to go through to do a do-over in district court with all of the protections that we are entitled to. I don't think, Your Honor, I don't think the district court has the option of somehow changing the sanction to get around that. I think this court, the Supreme Court in Nye, in Stewart, in Crow, in Bagwell, have made clear that reversal is the proper course, not remand for the district court to modify it. It simply can't be the case that you essentially get a get-out-of-jail-free card and don't have to apply the constitutional protections required both by due process and by sovereign immunity.
Isn't there an 11th Amendment problem with monetary sanctions?
Yes, absolutely, Your Honor, and that is the second way in which these fines violate the Constitution, and that's Edelman versus Jordan. The Supreme Court made clear that this sort of fine violates state sovereign immunity, and that is an alternative independent ground for reversal as well on top of the criminal contempt. And I see that my yellow light is on, Your Honor. I want to address more fully your question about what happens next in the district court and just make a few points about our request for reassignment. The district judge has made clear that she is deeply passionate about this case, the state's foster care system, and the children in the state's care. But it's also become clear that the judge's passion and conviction have clouded her ability to preside fairly and impartially, or at least with the appearance of impartiality, over this case. Regrettably, the judge is no longer a dispassionate arbiter. She is a jealous advocate. No one has an issue with a tough or demanding judge, but every litigant is entitled to a fair and impartial judge. My clients are and will remain deeply committed to the safety and welfare of the children in their care, but to do their job and faithfully serve those children and the people of Texas, they need a fair and impartial judge at the helm of this important case. Reassignment is a serious step and one that we have solemnly and seriously requested, but it's amply warranted by the serious appearance of impartiality problems in this case and the federalism concerns in this case.
In your rebuttal time, you let us know if you can point to any decisions that the judges made that have tainted lifetime hostility.
Yes, Your Honor, I'll be happy to. Thank you, Your Honor.
Thank you. All right, Mr. Yetter. Who brought this contempt motion?
We did, Your Honor. May it please the court.
Why and when?
We brought it in the spring of 2023 based on a number of monitor reports. Another monitor report came in, I believe, in September of 2023 that highlighted the conclusion of the monitor's investigation into this particular unit, the Provider Investigations Unit of HHSC.
Well, there was something cited in the briefs about the judge telling you or saying something about why didn't you file a contempt motion? Am I misquoting or misunderstanding?
No, Your Honor, you are quoting a discussion that happened at an earlier hearing, but Your Honor, on behalf of the children, we are the ones that make that decision. The judge was very frustrated at the time. This was earlier in 2023. I actually was not at that hearing, but we make the decision, and we have been very careful, and the judge has been careful.
She's the one who raised the issue.
She mentioned the issue, Your Honor, but I would respectfully disagree that it was her idea. On behalf of the children, we make those decisions. But if I could, Your Honor, the question that this appeal raises is not about the Texas foster care system, what it's been in the past or where it is even today. The question is what it will become. Because 10 years ago at trial, the state was in denial. It said there was nothing wrong. It had the safest system in the country. As this court's opinion in Stukenberg 1 recounted, the evidence proved the opposite. Today, 5 years after the remedial orders took effect, we've seen progress, but it has been both slow and halting. The state's approach has been delay, not cooperation, and improvements, and we welcome the improvements, in some areas came with shocking revelations in other areas. This appeal is about what's ahead for these children. Every positive step has been pushed, that the state has accomplished, has been pushed by the encouragement or the insistence of this district judge. She has been the state's biggest cheerleader. Yes, Your Honor.
That's all nice rhetoric, and it's well said in your brief. But the state has invested $150 million in what, 5 years?
Yes, Your Honor.
5 years, $60 million for monitors, and you say they are dragging their feet, they're intransigent, they're not willing to cooperate. Where's the money going?
Let me put that into context for the court, Your Honor. This is a $2 billion a year agency, DFPS, $2 billion budget every year, $4 billion for biennium.
I understand that, but this is not a small amount of money.
It is not, Your Honor, but what we're talking about is reforming a system that this court upheld, constitutionally violated.
This court upheld 60 out of 90 remedial orders on Stukenberg 1, which means that the district court erred in 1/3 of the orders that it issued. So from the very beginning, the district court had very aggressive intentions for its ability to monitor the system, and that plus Stukenberg 2 and Stukenberg 3, which you say what they say, obviously. So, you know, to me, I think we have to be a little more precise and focused in saying what justifies this contempt order vis-a-vis if you're really going to defend it as criminal contempt, if you're really going to defend the sanction as against an 11th Amendment challenge, and finally, against a claim of substantial compliance.
All right, let me address your questions in the order that you first gave them. To put into context the $150 million, Your Honors, that's 1.5% of the budget for this agency every year. 1.5%. That is to reform what this court says were shockingly haphazard and inefficient record keeping, a cycle of crisis that allows children to fall through the cracks, systemic deficiencies, an alarmingly high investigatory error rate. So this was a broken system. The state, as Stu...
Now, I thought the compliance rate overall was plus 90% in many of these areas.
And Judge Wilson, you're exactly right. And that would not have happened but for the injunction order.
But it's happened.
But it happened.
But
It has indeed happened.
I mean, it strikes me that you want to be very global when you're talking about the magnitude of the issues and whatnot from a decade ago forward. But you want to be very local when you say, wait, substantial compliance, let's look at this PI division, and that's it, and that justifies contempt. How do you have that both ways?
This is exactly why it doesn't work for the state. Because the agency that is in charge of investigating this group of children's outcries of abuse and neglect is the HHSC. As far as we know, this is the only group of children, and they're a special group of children. They're developmentally disabled. They are essentially 70 IQ and below. Even if this hadn't been carved out and given to HHSC, if DFPS, if any state agency had said, I'm going to do proper, thorough, timely investigations for all children except this discrete group of developmentally disabled children, we would have moved for contempt. Because it's not enough to say.
But it's two rules, each of which does not specifically distinguish one group of children from another. And every group of children matters, to paraphrase a current, statement.
They do, Your Honor, but this group is distinctly set aside.
What legally it is not, that's what I'm suggesting to you.
Administrative, as an agency matter, they have carved out this group and given it to HHSC. And the problem is, and we absolutely applaud the improvements on behalf of all the children, but the reasons why the other children are having investigating their reports of abuse and neglect much better is because the rules they are following are the opposite of the rules that this group, Provider Investigations, is following. Provider Investigations is not doing timely investigations. It's not doing keeping the child's safety needs in mind.
I'm sorry to interrupt, but this entire order, 127 pages describing it, only deals with 38 instances which only involve 13 kids, right?
Yes, it does, Your Honor.
Now, in this realm of the PMC, as I understand it, there are 80 to 100 kids. Is that right?
In the realm of, yes, for this group, Provider Investigations.
The provider one that you want to hold them in contempt for.
Yes.
80 to 100, and you're talking 13 kids.
No, we're talking about 60, a little over 60 investigations that the monitors looked at. 55% of them were defective. Recall now, in Stukenberg 1, the investigative rate was, the error rate was more like 75%. But no one, certainly not the state, can come to this court and say 55% error rate is permissible, is enough.
And how many kids on an annual basis are in the custody or care of these of this overall agency?
Of the total HHSC?
Correct.
For Provider Investigations?
No. Every kid in the foster care system, 8,000, is that right?
8,000 PMC children, yes, Your Honor. Those are the long stayers. That
Right,
this case is only the
8,000.
long stayers.
Okay, that's what I was trying to get in perspective. So,
But Your Honor, we respectfully submit, it is no answer for the state of Texas to say, this group, this agency, HHSC, has got a terrible record with investigating reports of abuse and neglect for developmentally disabled children, but that's okay because a different agency for different children has a much better record. The reality, we believe, is that all agencies that are investigating reports of abuse, neglect, and exploitation have to follow the same rules. And the state can't say, because we're doing well over here with these children, it doesn't matter what happens to the developmentally delayed children.
I understand that, sir, and you've used almost half your time with back, so move on.
All right, yes, I will, Your Honor. And our point, and if I could get to a question that Judge Wilson asked, this order doesn't penalize the state of Texas ad infinitum. That's frankly a ridiculous position for the state to take. But Judge Wilson, that's exactly the position they're taking.
Their position is that there's no way they can cure these past violations. So my question was, then what does that mean for the daily accrual of this fine?
And your logic is exactly right. If they're correct about how to interpret this order, the sanctions would go on forever. But they're not correct. Respectfully, Your Honors, this judge has been very careful again and again to give the state of Texas, both agencies, HHSC and DFPS, as many chances to do it right. And there's been 3 contempt orders. Every one of them, this judge has said, I want to give you a chance. This contempt order, Your Honors, has a compliance date hearing, at least it was set, 2 months after the contempt order. What was that for if it wasn't for the state to come back and say, we are now in substantial compliance because we will do everything, as the district judge defined in her order, quote, to show substantial compliance, a defendant must show that it took all the reasonable steps within its power to ensure compliance with the order.
But when you're talking about 2 orders, each of which has a 60-day deadline, but for a request for extension, and you supposedly proved to the court that those deadlines weren't met, how can you substantially comply? Because
what the district judge was telling the state is do it right now.
Well, I'm sorry, but you know, we worked hard on a very quick opinion staying this, and that was not evident from the way the order was written as far as we could tell. I'm not... Maybe it lacks clarity.
But respectfully, I don't think the state wanted a fixable order because they didn't go back to the district judge and say, well, tell us what this certification is about. What about prior untimely investigations? How do we show you substantial compliance? And what we believe, the district court said, because the district court's order talks about that, for example, one of the things Judge Jack relied on is that and this is at Record on Appeal 53-117 to 118, is that the state, and specifically provider investigations, had failed to take any action to remedy the egregious flaws identified by the monitors. This was no surprise. The monitors started looking at provider investigations in 2021. In early 2022, the monitors issued a report saying they were looking at provider investigations. The contempt trial was not until December 2023. What Judge Jack is saying is you're not listening to the monitors. You can fix these. Go back and do the right investigation.
Whatever that means, okay, we'll agree to disagree with you. Please move on.
Okay, so we believe it's a civil sanction that the judge made every effort to make it clear throughout her opinion that I want to convince you, coerce you to be in substantial compliance going forward. Second, we do believe, Judge Wilson, you asked this, or Judge Jones, actually, you asked this question, if it goes back down, and there is, and at this point, we believe it's absolutely undisputed, the facts of the violations are not in dispute, that the proper, if this court were to find that it was a criminal sanction because of the way the wording of the sanction in terms of the time period that was covered, that this court could well, and has in the past, say that the sanction needs to be fixed, but the liability finding, which we believe is uncontested, the state didn't put on any evidence that any of these investigations were in fact proper. They put on no witness on this issue at the contempt trial, even though they had full knowledge of it. but that the court could vacate the sanctions, but affirm the liability finding and direct the district court to correct or modify the sanctions.
Your best case for that proposition?
The Lamar financial case.
The what?
The Lamar financial case, Fifth Circuit, 1990, Lamar Financial versus Adams. It was a discovery dispute. The defendants didn't want to provide documents, and this court, the Fifth Circuit, said the contempt findings were partly criminal because they punished past conduct, and partly coercive and civil because they were forcing the defendants to produce the documents. And this court reversed the punitive portion and remanded, but affirmed the future-looking coercive civil sanctions.
That's cited in your brief?
It is, Judge Jones. Lamar Financial, 918 Fed Second, 564. No, there were none. Nothing was paid.
We suspended the fee,
That's,
really suspended it, but
you did.
has it technically been accruing this entire time?
No, Your Honor, not to my knowledge. The district judge has basically stood back and done nothing.
Well, let me ask you one other thing that sort of bears on this situation, and Will, are you finished with the criminal civil contempt issue?
Yes, and the other point, Judge Jones, that I was trying to make is the evidence of violation is undisputed. But let me take your question next.
Yeah, well, the briefs are very clear about the violations, but I asked my law clerk what else the plaintiffs had moved for contempt on in January, and we didn't have time to read the 250 pages of the order that discussed other remedial provisions, and we ended up with this chart which lists about 12, at least, of the additional decretal provisions that the plaintiffs came after the state for. So I'm concerned that when the district court holds an additional hearing in September, it's going to say, well, look, I ruled on this in January, facts are out there, now you're in contempt of all these positions, and this time it's not going to be criminal, it's going to be civil, and I'm going to put someone in jail until they are complied with.
That's certainly what the state is leading the court to think is going to happen, but two big reasons, Judge Jones, that I do not believe that's going to happen. First, the district judge could well have done that with this order. We had a trial, a criminal contempt, civil contempt trial in December. We put all of this evidence on. Some of the evidence is, from our perspective, just shocking, and the district judge did not enter any findings of contempt. Instead, she went at length to say, I want to give you guidance to the state. Second, there's history on this, because this is the third contempt order from the district judge over the span of 5 years. The second contempt order in December of 2020, the district judge found violations of 13 remedial orders. 13 remedial orders held the state in contempt, but did not issue sanctions. Instead, set a compliance hearing 6 months out and said, show me in 6 months that you've complied. Now, what the district judge has basically said now is, I'm giving you guidance. These are serious issues. I want to give you a chance to comply. This district judge, I think the evidence, frankly, is undeniable that this district judge wants nothing more than a safe system for these children and has tried from the beginning to work in partnership with the state.
The threat of a receivership is quite the opposite of a state system, number one. Number two, the statement that I think is more than once about, I think you're never going to get out of this indicates that the judge thinks she's in there for the long term.
To response to both of those, Judge Jones, in the hearing, and we put this toward the end of our brief, Judge Jones, the district judge said, I'm going to tell you one thing right now. I'm not granting a receivership. I have not seen any evidence that it has done any good wherever it's been applied. So this judge is not showing. We may, as advocates for the children, suggest that enough's enough and perhaps a receivership should be considered, but that's not what the district judge is doing.
But you're just quoting something that was in a hearing. But anyway, and what do you make of the statement that's referenced in the state's brief about, I'm going to increase your attorney's fees. I'm so mad at the state, I'm going to increase the plaintiff's attorney's fees. What is all that about? What is this trust fund for attorney's fees?
Very briefly, Judge Jones, we're not getting any attorney's fees. We're doing this pro bono, but the fees that we would get if we were not doing it pro bono have been set aside into a trust for the children. The district judge we have said the district judge should have control over how it's spent. The district judge has again and again, as have we on behalf of the children, offered that money, which would have been fees that they would have had to pay to us, to pay for whatever the state thinks will help the children. Literally that broadly. It has paid for one thing so far. An expert panel of 3 child welfare experts from around the country came together to try to solve a problem of children that they're being placed in unlicensed placements. The panel members met. They gave a long list of recommendations. The state has ignored all the recommendations, has not put them in.
No,
so there's.
Wait a minute. I'm very confused about this because how does this comply with the PLRA?
Meaning, Your Honor?
Prison Litigation Reform Act.
We have voluntarily put those fees into an account that is in trust for the children. We earned them by prevailing under the Civil Rights Act, and the judge has awarded them. And by no means has the judge awarded all of our fees.
What's your best, I've never heard of this arrangement before, so what's your authority for that legally?
That's a good question, Your Honor, and I don't have a case to cite to you. It's been in place for probably 3 years, and the state has never challenged it.
Okay, well, that was, and obviously that's not before us directly, but I must say it's a sort of troubling arrangement because, now when defendants pay money into class action settlements and district judges have tried to create cypre arrangements, those have been rejected.
Fair enough, Your Honor.
And this seems almost like an indirect cypre.
It is not, Your Honor.
Well, it is in a way because it's just you giving it to the judge and the judge spending it.
No, it is only going for one purpose, Judge Jones, and it is for the children. And we have offered it back to the state repeatedly for the state to spend on something they think is worthwhile for the children, and the state won't take the money.
All right. Now, as I said, I'll give you a minute on the reassignment question.
Reassignment.
You point out correctly that the state has not really challenged the underlying facts on the contempt, but I don't think you're really challenging some very extreme statements by the district court that they raised to show lack of impartiality.
Your Honor, I think what we tried to do, the statements are the statements, but I would suggest respectfully that they are nothing more than the frustration that this court in Stukenberg 1 said, and I quote, "We understand the district court's frustration and we agree remedial action is appropriate." We're now 5 years later, and the district court has said some things that reflect impatience, frustrations, sometimes even anger at the new revelations of child harm. But put it into context, and that's what we tried to do in our brief, Judge Jones. Put it into context, and this judge has done everything in her power we respectfully submit, to try to help the state accomplish what these remedial orders are destined to do, which is a safe system. This district judge wants, and she has said this, and we put it in our brief, wants nothing more than to see the orders complied with and this system to be safe and her role to be gone. Now, that doesn't mean that at times she's been frustrated. There's no question. But I would, frankly, to put it into context, the state comes to the court saying, we just want to work as a partnership. But that has not been the case almost from day one. Recall that, as I said, originally the state denied that there was any problem. Then after the liability finding, the district judge said, state, come help us draft remedial orders. As this court in Stukenberg 1 noted, the state refused to cooperate in the remedial orders. And now they're, of course, they're complaining about them.
That's 3 appeals ago.
It is, Your Honor, but it hasn't changed. I just have to tell you.
That side has prevailed in the subsequent 2 appeals. Essentially, I mean, you could say that 1 or 2 things were approved in Stukenberg 2. Stukenberg 3 is clear on his face that the judge was, going too far.
I would actually rely we believe, some of the best response to the state's position that this is a judge gone rogue is this court's own statements, not only in Stukenberg 1, but in Stukenberg 2, where the court said the slight change that the district judge made to the face-to-face visits, the court described it as a, quote, well-intentioned attempt to fix the problems. The court rejected it, but it was done in good faith. And likewise, the computer overhaul point, this court said that the district judge had faithfully adhered.
I don't disagree with that, but then the judge comes back later and says, well, you need to redo that computer thing anyway.
That context of that comment, as the state didn't make clear in its brief, was there was a dramatically shocking situation in Bastrop, Texas, where a facility, a state approved facility for young women who had been sex trafficked, the revelation came out that caregivers at the refuge, at the Bastrop facility, had been participating in trafficking the children, the girls. The judge was talking about a law enforcement comment at the time in doing an investigation that couldn't match up the information because the computer system for the HHSC doesn't talk to the computer system for DFPS, and she was frustrated about that, and she clearly knows that she cannot order that, but she made the point, and perhaps maybe she shouldn't now that the state wants to make it seem like she was going out of bounds, but she was making the point, here's another example of how having a unified computer system would help the children. As we sit here today, Your Honors, you might be surprised to learn that the state of Texas cannot tell us today where every child under their custody, in PMC or otherwise, will sleep tonight because their computer system does not have that capability. I'm not here to argue for the computer system. We've offered that money, that set-aside money, to fund a study on how much it's going to cost, but that's the backstory of the quote that the state pulls out to say this is a judge gone rogue. Respectfully, we disagree with that. This is a judge that wants nothing more than this system to be safe.
Okay, thank you.
Thank you.
All right, Ms. Ho?
Thank you, Your Honor. I'll make 3 points. The first 2 are quick, and then, Judge Clement, I will focus on the question that you asked me at the end of my opening time. Number 1, Judge Jones, to your question about the order here, I think the proof is in the pudding, and this is what the order says. This is on 591, 53129. Quote, the court is carrying forward plaintiff's motion for partial receivership. The court is also carrying forward plaintiff's contempt motion as it relates to CWOP, caseworker caseloads, heightened monitoring, psychotropic medications, and appropriately apprising PMC children of the ways in which to report abuse and neglect. A compliance hearing will be held, gives a date and a time, at which time, absent substantial compliance, any previously abated fines may be reinstated. So we don't have to speculate about that. The order itself makes clear. Number two, let me address.
What's the record site for that?
Yes, Your Honor, let me make sure I'm looking at the right thing. I think it's 53129.
Okay.
Is that right? Yes, Your Honor.
Okay.
Yes. I've got several numbers stamped on this page, so I wanted to make sure that I gave you the right one. Number two, let me address the Lamar Financial case that my friend was citing. What that case actually held was on the merits. It actually reversed sanctions as being criminal and not being imposed. There were other sanctions imposed which the defendant there did not challenge as being criminal. The only issue that the defendant in that case took issue with was the amount of the fine. So that was not a case, Your Honors, where there was a modification of the contempt finding. And finally, let me focus, Your Honor, on your question that you asked me. I think, Your Honor, the statements that we've talked about today and that we lay out in our brief, I think those statements speak for themselves in terms of statements that reflect that the district court has regrettably become hardened in her views against the state defendants. I would point, Your Honor, to the statements where the district court, as able counsel, able friend on the other side admitted, the district court did request that plaintiffs draft a contempt motion against the defendants because, quote, I can't write it for you, and then suggest edits to that. That's ROA 63147, who openly defies this court to favor plaintiffs saying, quote, I know the Fifth Circuit prohibited me from talking about a new computer system, but I'm going to talk about it anyway. That's ROA 60799, and who tells the state defendants, after they've exercised their sovereign prerogative not to opt into a federal program, quote, now that's giving up a whole lot of money for these children while still complaining, I might add, as an aside of the monitor's fees, as well as it makes me wonder what on earth I could fine you by way of sanctions. And that's ROA 598, 16 through 17. And concerns about impartiality, and I think it's important to bear in mind that the standard here is not proving that the district court's partiality has infected any rulings, that the legal standard under both of this court's tests is the appearance of impartiality. And I think concerns about impartiality and fairness loom especially large in this case, Your Honors, given the serious federalism concerns raised by the institutional reform injunctions which allow a federal judge to superintend state officials performing core state functions with no end in sight, and again, under the threat of the receivership, which is written into the order under review.
If we were to reassign this case to a different judge, how would we learn the background and
Thank you for that question, Your Honor. I think, if anything, Your Honor, we're at a particularly opportune moment in this case for reassignment. There is a liability finding. There is a final judgment. The only questions remaining are the extent of our compliance with the injunction with a view toward ultimately returning this control of the foster care system to the state of Texas. And those questions involve new facts and looking at the text of the order. So we think, if anything, and as I think you mentioned, Judge Jones, this is our fourth trip to this court on this injunction. Given the contempt order I just read, I think it's fair to say that it probably won't be the last. And so I think there are, if anything, efficiencies to be gained here, Your Honor, by reassignment at this particular juncture, where all that remains is looking at our substantial compliance with the injunction. And just one final point, and Judge Jones, in response to your question about where the money is going, let me just cite one statistic. Since this court first saw this case in Stukenberg 1 back in 2019, the improvement, just looking at the investigations at issue, it's been an improvement of 63% in 5 years. And so we respectfully request that this court reverse the contempt finding, and with great solemnity and even sadness, Your Honor, we do request that this court exercise its prerogative to reassign this case on remand.
Two final questions. Number one, how much money is there actually a trust fund with the attorney's fees in it?
Your Honor, my understanding is that is the case, that
How much money is in there?
I don't know how much money today is in it. I know that we are, the state defendants are billed for attorney's fees. We pay those bills, honestly, the rest of it
Well, I'm
is a
not
little
denying
confusing,
that
Your
the
Honor.
plaintiff's counsel have done great work. I just wanted the amount of money. Second question is, does this judge hold some of these hearings not in person?
Yes, that is correct.
What kind of hearing, how often are, for instance, this business in January, and I should know this, I guess that was an in-person hearing. Is that right? Your counsel?
So I think there are a lot of hearings. The show cause hearing, which was December, that was an in-person hearing. The status, I think there was a June status conference, and that was via Zoom. That was on a remote basis. And most of the, what I'll call SNAP hearings that the district court sets, where she demands that the state executive commissioners attend, are, to my knowledge, are remote.
And what else is it? Well, something, I thought of something. Okay. All right, we have the case. Thank you.
Thank you, Your Honors.